Okay, well, good afternoon, or good morning, I guess, to most of you. My name is James Wood, one of the editors at the Legal 500, and it's my great pleasure to welcome you to our webinar today, Restructuring and Insolvency in Mexico. Now, the proximate occasion for this webinar is quite clearly the COVID-19 pandemic. That's not only meant that we're forced to interact with people through webinars, but it's also placed a great number of businesses in financial distress. And obviously, there have been recessions before, but this one has certain unique features to it, which we will be hearing about today. And I'm very pleased to say that we've got an exceptional cast of speakers who will be talking us through both the bigger picture, things like what does this distress mean for cross-border insolvency and restructuring, how is Chinese financing changing the nature of the restructuring markets, but we'll also be looking at specific details of what's going on in Mexico right now. So the session will be led by Alejandro Sainz-Orantes, a partner with Cervantes Sainz. Alejandro leads the insolvency and restructuring practice and also the M&A, or mergers and acquisitions practice groups at the firm. He is, among other things, one of the leading experts on cross-border insolvency procedures and restructuring in the region, and is also hugely experienced and respected advisor to corporates in Mexico, the US, and elsewhere. We will also be hearing from Stephen T. Kargman. Stephen is founder and president of Kargman Associates, an independent strategic advisor that assists with complex and challenging international restructuring work, with a special emphasis on emerging markets. Stephen's played a leadership role in many of the largest and most complex restructurings in the emerging markets, including several in Mexico. He was formerly lead counsel to the Export-Import Bank of the United States, which, as I'm sure many of you know, is the official export credit agency of the US government. And while he was there, he represented the US government in many of its largest corporate debt restructurings in the emerging markets. He has also, among other things, served as the general counsel of the New York State Financial Control Board. That's the chief financial oversight agency for New York City. So a very useful man to have on the webinar. Welcome, Stephen. We are also joined by Brock Edgar, who is Senior Managing Director in the Turnaround and Restructuring Practice at FGI Consulting. Brock has over 20 years of experience working exclusively on large multinational restructuring assignments in Mexico, the Caribbean, and South America. Now, I should also note that Brock has advised, I believe, either the creditors or the company in almost all of the significant restructurings that have taken place in the Mexican manufacturing sector during the last 20 years. Is that correct, Brock?
Yes.
That is correct, excellent. He's also, to date, been involved in the successful restructuring of more than $150 billion worth of indebtedness. So again, an incredibly useful man to have on the line. Thanks, Brock. And to top things off, we have Daniel Nikolaevsky, who is co-head of Mexico at Rothschild & Co Global Advisory. Daniel has extensive experience on a wide variety of restructuring, M&A and capital markets transactions in Mexico, the US, Canada. Prior to joining Rothschild, he worked in the recapitalization and restructuring group at Moelis & Company, New York, and in the restructuring leverage finance group at UBS and Proto Evercore, Mexico. He has a PhD in economics from Harvard University and a BA in economics from ITAM, and we're hugely grateful to Daniel for joining us today and giving us the benefits of his extensive frontline experience from the banking side of things. Okay, look, just a few quick words on housekeeping from me before we get into it. It goes without saying that our 4 expert speakers today will be giving us a masterclass in restructuring, but we also want this webinar to be as beneficial as possible to you in the audience. So if you have any questions, comments, or issues you would like to raise, then please do so using the chat function, and we'll try to address these through as we go on. Well, with that said, I will pass over to Alejandro of Cervantes Sainz to kick us off. Alejandro, welcome.
Thank you so much, James, and it's really a pleasure to be, sharing this panel with me, with my good friends Stephen, Brock, and Danielle. Thank you so much for participating, and on behalf of Cervantes Sainz and the Restructuring and Insolvency Practice Group, it's always a privilege being part of this type of seminar, Bill 500. So thank you, James, and to all your team. So, we have a very interesting times right now with respect to restructurings and insolvency matters going all the world. Always it has been a very interesting subject for us that we dedicate, our professional lives into this. But, lately, as a consequence of the unfortunate pandemic of COVID, the things has been stressed even more, as we all know, no? So the idea here is just to have, a conversation among friends, as we are, Brock, Daniel, Stephen, myself, and to share with you some ideas, to exchange some views on what's going on, what are the trends in the markets, basically to have an open discussion with you. And thank you so much for the audience here for your time right now. So if you want, we can start. I would like, Stephen, thank you so much again for your participation. It's always a great privilege sharing the panels with you. We have done it many times physically, but right now it's the new trend, no doubt, for all of us to participate from home and to take advantage of the technology to participate, I would say, in even more webinars. No? So always we need to take a very positive approach on what's going on. So Stephen, would you mind, sharing with all of us, I have a question basically for you, what COVID-related economic developments in the emerging markets will give rise to financial distress and debt restructurings in the emerging markets globally? Would you mind sharing your views with all of us?
Sure, and thank you very much, Alejandro, for inviting me to participate with such a great panel. Obviously, with the lockdowns, not just in North America, but around the world, the global economy has slowed dramatically, particularly in the second quarter. And the forecasts by the multilaterals are fairly bleak for the global economy as a whole for 2020. The World Bank, for example, predicts that growth will be minus 5.2%. IMF in June said minus 4.9%. And the emerging markets will record, according to both the World Bank and IMF, their drop will not be as sharp as the global economy. The IMF says minus 3% and minus 2.5% according to the World Bank for the emerging markets and developing countries. But as the World Bank reported in a report in June, this is the slowest rate of growth for the emerging markets for many decades. Actually, they say going back to the 1960s. So we're facing truly an unprecedented situation. And there are a number of factors that have contributed to this. Obviously, the sharp drop in commodity prices, most significantly in oil, but in other metals like copper and zinc and so forth, have had a very serious impact on many emerging markets that depend on commodity exports to fuel their economies. And so obviously the oil producing countries have been very hard hit, but these other commodity producing countries have been hit as well. There's been a major outflow of capital from these emerging market countries. Economists like to call that the sudden shock, when there's a sudden reversal of capital flows. And earlier in the year, as a result of the COVID crisis, there were estimates that $80 to $100 billion flowed out of the emerging markets. There's also been a major depreciation of currencies of emerging market countries around the world, whether it's the Mexican peso or the Colombian peso or the Brazilian real, or in Nigeria, the naira, the South African rand, the Indonesian rupiah. This also has a very serious impact on these economies, and particularly for our purposes, it makes it more difficult for these countries to service their foreign denominated debt. And another factor is the slowdown in remittances to many of these countries. Latin American countries, many of them depend on the remittances coming from the overseas workers, but this is a global phenomenon. Countries like the Philippines, they get a good part of their foreign exchange from the remittances from their overseas foreign workers, and that is expected to drop sharply. Of course, the disruption in trade and supply chains, that also is having a negative effect on these economies. So overall, it's not too promising a situation, at least through the end of this year, for the emerging economies. And all of what I've been describing will create financial distress that'll affect the companies as well as the governments and their finances.
Okay, great, excellent. Look, Stephen, we'll come back to some of these wider trends slightly later in the webinar, but I actually want to go to Alejandra now, if I may, and ask how these wider trends that Stephen's just outlined, how are they affecting the situation in Mexico? What's your perception of the realities on the ground?
Yeah, I mean, there's no doubt that in Mexico, as it is going on in all the world, in the rest of the world, the economy has been affected seriously, particularly in airlines, in retails, entertainment, and so forth. But of course, as Stephen was explaining, this is a chain of negative effects in all the levels of the industry, including supplies, automotive, and everything. On the top of that, in Mexico, we haven't had the type of direct support or loans that you have experienced in other economies like US, Canada, even in some countries, South America, and for sure in Europe. So the companies, even though that the banks are willing to collaborate, and I think that there's a real atmosphere of support with respect to creditors and debtors at all levels. Things are complicated. At the beginning, I think that all of us, we thought that this would be a matter of weeks, 1 month. I remember when we were in March and we were thinking probably by the end of April, probably I could reactivate even my own trip. And now we are in the middle of August and we continue in this situation. And this is gonna continue having negative effects. So we have see an escalation on restructuring matters at the beginning out of court, I would say, since our courts were closed for several months and they just are reopening with many struggles. And on the top of that, in Mexico, unfortunately, as you know, we're still in the peak of the pandemic. So it is not that we have a lockdown and then we're just trying to control. Of course, we need to understand the economy of Mexico, the size of the economy, and for low class, it is of the essence to continue working to survive.
Yeah, sure. Okay, great. Look, just a quick reminder to those of you in the audience, if you have any questions, comments about anything that the panel are discussing, please do use the comments box. Alejandra, I just want to ask one further question to Daniel and Brock, just to bring them in before I hand back to you as MC. If I may say,
no, of course.
Daniel, Brock, I mentioned at the outset that obviously there have been recessions in recent memory, but this one has certain unique features. I mean, is that accurate? What, if anything, is unique about the current COVID-19 pandemic? What are you seeing now that you didn't see in 2008? So I'll leave that as an open question to both you, Daniel and Brock.
Daniel, do you want to go first, or do you want me to go first?
Sure, if you want, I'll kick it off, Brock. So look, I think this crisis does have some key differences vis-a-vis other crises. In my view, I think that among other things, some of the key difference has to do with the speed of change of these, at which all things have happened. Number one, number two, the depth of the change, and number three, the uncertainty about timing and speed of recovery. And what I mean by that is with respect to speed of change, I mean, as you guys probably saw, I mean, there were many of these sectors that Alejandro was making reference to, they suffered very significantly in a very short period of time. What I mean by that, and to give a couple of examples, is if you look at the retail or the entertainment sector, for example, leisure, I mean, they suffer dramatic change overnight. And when you look at the rate of change month over month, for example, between March and April, which is March was more or less when the crisis really started in Mexico, what you'll see is that, for example, in the restaurant sector, in the entertainment sector, sales drop, 80%, 90%, just month over month. I mean, within 1 month of change. That's something completely unprecedented. Auto production stopped. from being, fully operational, just, manufacturing stopped to zero. Auto exports dropped 88%. So the speed at which change happened was very significantly. Second, with respect to the debt, I mean, we've never seen before sales dropping to these levels, right? I mean, from 100 to 0 or 100 to 10 or 20 just month over month. This is something totally unprecedented. And then surrounding all this, the uncertainty about what's really going on. No one is really understanding what's going on or what's understanding what's going on. And then no one really understand when things are going to recover and how things are going to recover. Is it going to be a recovery of, within a couple of months, or if it's going to be a recovery that it's going to drag for a year or so? So all of that has certainly, very significant impacts in what we've seen in companies. One of them, and one of the most important, has to do with liquidity, right? I mean, what we've seen is really companies suffering a lot and not being very prepared for these on one hand, and the banking sector on the other hand as well. So one of the things that really, or one of the implications of this speed, debt, and uncertainty in our view has been that, we're seeing a cash crunch in many of these companies. But let me stop there. Brock, I'll turn it to you to add on this point.
All right, thank you, Daniel. I'll just compliment, and I'll go on the theme where Daniel has gave it on a silver platter. Yeah. Good companies are now in significant trouble, and typically in Mexico, we see companies where we have a balance sheet restructuring. You go back to 2009, basically it was the toxic derivative crisis. I would characterize the Mexican restructuring in 2009 and 2010. Now we're in a situation where companies don't have the money. They've drained their resources. As Daniel said, you go down 80, 90% in sales, you're basically in preservation mode, and you get to the point where you've drained all your liquidity. And the one thing that the laws in bankruptcy in Mexico and throughout Latin America are not good at is facilitating liquidity coming back to a company that is in desperate need of it. So we're in a situation, if you think like the auto industry, where Daniel referred to, it went down to zero overnight. Auto industry, the big three pay everyone in 45, 47 days. You have 120 days of payables. That 120 days has reversed. So what's going to happen is not only did you stop production, you lost your sales, but effectively you had a debt payment in the auto industry, for example, because all of a sudden you had to pay down your payables, which are usually much greater than your receivables, and your receivables all got paid very quickly. All of the big OEMs paid in the normal course. You go to the other sector that Daniel referred to in the hospitality sector, you have a whole bunch of prepaid reservations, and all of a sudden nobody's coming to your hotels. Most hotel companies do not keep your deposits on rooms that you've prepaid in a separate bank account, and all of a sudden you have to give back all those funds to people, and the credit card companies are refunding people that use the credit card. So, if you're a major chain, you really have to give back the money to the credit card processors, or you're going to have no way forward. So the contraction, not knowing when the recovery is going to be. So how do you predict what the hotel industry is going to be? How do you predict the airline industry today? You can have your best guess, but it's going to change dramatically moment to moment. And so the uncertainty in the restructuring and the need for cash is totally different. In the last 20 years, we've probably been through, I don't know, Daniel, 5, 7 scenarios of any magnitude where we needed some new cash. But right, for the most part, we managed to go through the restructurings without new cash. And, a cultural thing is shareholders don't want to give up control or dilute themselves in Latin America. And now we're going to be in a situation where we need to get cash. We have banks that are, currently have been lending to their good customers, but they're having to choose which customers they're lending to. And, you know, they've gone on a moratorium in Mexico basically for 6 months. What happens at the end of the 6 months? What happens when companies need to invest to recover? And they basically drain their resources and don't necessarily have the access to capital to recover and rebuild the position. So I think it's a totally different scenario than what we've seen in the past, where, you know, Latin America is a balance sheet restructuring haven typically. And now they can't operate. They don't have the means to come back to the same level. They're having to make choices. What am I going to do? What level of capacity can I do? And, you know, the financial institutions may or may not be there to be able to support them, and how much more lending is available to support the recovery.
Yeah. And the one thing that I will add to that is also, in this instance, it's not only I mean, the impacts are not only financial, they're also business impacts. And this is very important because it's not only a matter of really restructuring the company's balance sheet, it's also a matter of changing the way that companies operate, because business models change for a period of time, but change. I mean, the supply chain changed, the business model changed. I mean, in some markets, it completely changed the demand side of the equation. So there are very significant implications vis-a-vis the other restructurings, as we stated.
Yeah, and a good example of that is you're seeing in the hospitality industry in Mexico. The big problem is who's going to be covered for health insurance when they come down to Mexico in the short term. And you're starting to see some of the big chains trying to figure out how can they actually include health insurance as part of the package when you're booking a trip. And so the dynamic that no one would have ever seen before or ever even contemplated.
Okay, great. Excellent. Look, we have, I think just now is a good time to take a question from the audience. So someone has asked whether you foresee, and this is open to all panelists, whether you foresee Mexican SMEs kind of getting caught off guard with large Mexican businesses slipping into insolvency, whether there'll be a trickle-down effect that's going to actually really impact the wider economy. What are your views on that?
You can take it, Daniel. Go ahead.
Sure. Look, I think definitely. I mean, actually, some of the companies that are suffering the most are those, right? I mean, small, medium enterprises in Mexico are really suffering. I mean, when you think about large corporations here in Mexico, clearly their cash and liquidity chest is significant at any moment in time. They have either a revolving credit facility, they have significant cash, they actually have significantly weight on suppliers, and they can actually stretch their working capital. When you think about small, medium companies in Mexico, neither of them have, you know, access to revolving credit facilities, or very few of them. They don't have a big war chest to deal with these type of situations. It's not that they have access to you know, some potential investors. So these companies are suffering greatly. So no doubt that that, you know, these companies are going through some restructuring conversations with the different stakeholders at this moment in time.
Yeah, and I think it comes down to, like, you know, the way people think you're too big to fail. The big enterprises, some way, somehow, will find a way for them to survive. And the stakeholders, will be somebody that has to have them survive because the downside is too much. With the SMEs, at some point, it's a game of who survives, who doesn't, but you're not necessarily have the leverage of a stakeholder that has to have it survive. Third parties, and you know, a lot of these SMEs are owned by families, and they have all their net worth in the entity, and they really don't have more resources to support it. So I think the ones that will disappear the most won't be the large players, it will be the SMEs.
Yeah, something that I would add, I think that nowadays that there's a lot of uncertainty, the name of the game is to anticipating yourself as a company, as a creditors of debtor to a potential cash flow crisis in a company. I mean, we have seen many companies still in denial mode, or even banks just offering in good faith, let's say, just to extend the grace period for payment of interest. And this is really severe, no? Because as Brock, Daniel, and Stephen has been saying, this is really different to what we have seen in other years, even of what we saw in 2018 crisis, that it was, particular to certain sectors. All of the sectors are here being affected, and we don't know even if, in some areas the virus is coming back. So areas that we thought that they were coming back to business, they are coming back to certain restrictions. And that affects all the economics. No? So I think it's a matter of being open as debtor, as creditor, and to anticipate yourself on what you're going to need, not in 1 month or 2 months, but in 6 months, 1 year, or 2 years.
James, I might add a word from a global perspective. I think the SME sector globally in the emerging markets will be a big, big challenge in the coming period, because they don't have the resources, as has been pointed out, to weather the storm as easily. And moreover, there are so many SMEs in all of these markets. They're the major employers. I think there's going to be a problem once the stimulus measures wear off, once the moratoriums are over, that there's going to be a deluge of restructurings and insolvencies of these SMEs. The problem is there may not be the capacity in the courts, for example, to deal with the volume of cases that they will have. So some creative thinking will have to be done as to how there can be greater use, for example, of out-of-court restructuring techniques to deal with the many, many SMEs that will have challenges in the coming months and even years.
Great. Stephen, can I just very quickly ask you for a final bit of big picture before we move to Alejandro and Mexico? I mean, firstly, the kind of other types of restructurings that are likely to be triggered by this slowdown, but also whether you can make any comment on how the slowdown is going to affect the cross-border and insolvency market.
Sure. I think this current situation will give rise to various different types of restructurings. We've been talking a lot about corporate restructurings, and that will be an obvious pressure point in the economies going forward. At the sovereign level, there will be a need for extensive restructuring, because the sovereign balance sheets are being stretched very thin. The sovereigns are being called upon to provide stimulus packages. And so that could be very costly, even if the stimulus packages obviously are not on the scale of the stimulus and recovery packages we've seen here in the US. But you have the stimulus packages on the one hand, and then you have the required expenditures for the public health response. So sovereigns will be in a very difficult position in these emerging markets going forward. In fact, Fitch, the rating agency, said it expects a record number of downgrades of sovereigns this year. And already about 100 countries have approached the IMF for emergency loans. So that's another area, in addition to the corporates, to keep one's eye on. And then a third area would be infrastructure projects, toll roads, ports, airports. Airports are a good example because there's not much travel going in and out of the airports, both at the passenger level and the airplanes coming in and out. So the economics of these projects, specifically if they were structured on a PPP basis, will be very problematic. And so we could see major restructurings of infrastructure projects. Then we've been talking some about the situation of the banks, but if this crisis is anything like some prior crises, such as the Asian financial crisis, we might see a huge surge in non-performing loans. And the banks, but also the governments, will have to figure out what they're going to do with this new wave of non-performing loans. And a final area would be the state-owned enterprises. The SOEs in many of these countries were not profitable or efficient even before the crisis, and the crisis has only exacerbated their problems. For example, the airline sector in a number of emerging markets, there are many state-owned carriers, and the governments have been subsidizing them for years without any profits on the horizon. But now the governments are running out of money, so that's going to cause pressure to face up to the situation with the state-owned enterprises, the SOEs. Quickly, you asked me about cross-border. That's been a trend, of course, over the last decade and even longer, especially with the UNCITRAL model law on cross-border insolvency, the US Chapter 15 and so forth. But other countries, including Mexico, adopted that model law. But I think we'll see more cross-border, but there's a twist on this because I think companies in the emerging markets, we'll probably talk about this further, but they will be looking outside of their own borders if they don't think their own insolvency systems are up to the task of restructuring complex situations. They'll look to what might be called restructuring hubs, centers where insolvency and restructuring is conducted on a more efficient and even sophisticated basis, whether it's the US or London pre-Brexit, or in Asia, for example, Singapore has been bulking up its insolvency capability. So they're trying to position themselves for a number of Asian restructurings. We'll see how that plays out, but companies will be less hesitant to look to these foreign restructuring hubs. So that will further the cross-border insolvency trend.
Okay, excellent, great. Look, we'll come back to that in just a minute, but I guess I want to turn over to Alejandra now to get some details on, I guess, the process of restructuring. So, what's the recent trend you've seen, Alejandra, with regard to in-court versus out-of-court restructuring in Mexico? What's going on?
Yeah, I would say, that as Steve was saying, the companies and the advisors, we are open to any type of resolving techniques, So I would say that in general, any company that, to the extent that they can avoid an in-court proceeding, whether it's in Mexico or in other jurisdiction, of course, they will try to do it, and they will try to emerge from that quickly. In some cases, when there's a specific company just dealing with a specific issue, a mediation, could be an option. But again, we know that when we have complex situations in which this is a matter on having issues with all sorts of suppliers, bonds, commercial paper, that it's almost impossible to have access to new facilities. You need to think on a restructuring. The initial trends that we saw, particularly as I was saying, since the courts were closed, it is to try to implement the out-of-court solutions. But in many occasions, even that there's willingness for the parties to reach an out-of-court solution, it is important to be supervised by a court. So we have, our own system, as we all know, our concurso proceeding that they will go digger into that in a moment, that you have your pros, your cons, and also we have successfully implemented many pre-pack, particularly pre-pack restructurings in which Brock, Stephen, Daniel, they have also participated as advisors and operating advisors. The thing it is that, as Steve was saying, there are some cases of some companies that their financials are so complicated and they have a point of contact with too many jurisdictions and foreign jurisdictions, and they're in the need for getting financing, that is the reason that they go to other jurisdictions. And I think that we're going to see that trend coming more. Of course, for example, Chapter 11 is not for all the emerging companies. It is a very efficient process, but it's very expensive. So it is not doable for all of the companies. But again, what it is true is that we're going to see a lot of concurso proceedings in Mexico, out of court litigation. So our courts should be ready to implement in the short term those proceedings, because otherwise, if you have the willingness of a debtor and creditors to reach solutions, but then your framework is not capable to implement that, then you have an issue as a country, and then you have an issue as a rule of law. And I think that many jurisdictions will be tested in this manner. So better our legislators, our courts and our executive branch, they're open to implement amendments to our insolvency laws in order to allow companies to restructure in a shorter and expeditious time and giving certainty to both parties. This is not a matter on what jurisdiction is better for a debtor or for creditor. It's a matter on finding solutions and emerging with a real solution in the short term, or otherwise facing full liquidation. James, you're on mute.
Sorry. Hi, Daniel and Brock. What are your views on that? I mean, do they match what Alejandro is saying? Let's hope they do.
Yeah, I think largely they do. You know, our number one objective, and I think Daniel will have a similar view as I, is we don't want to go to court unless we have to. But it's an implementation tool. And as Alejandro pointed out, the real question is that tool effective to implement the deal that is struck? You know, if you go back 20 years in Mexico, we almost never went to court. Now it's changed where you have more of the capital markets, the bondholders that are participating in deals, and we try to go to court just to implement the deal, not necessarily to have what, you know, historically people would call a free fall filing, where you file without a plan, without support. That rarely works in Mexico and Latin America. So we tend to try to do everything out of court and then implement through a court if necessary. But if we can avoid it, generally as a community, restructuring community, we try to avoid it. Daniel, do you have anything to add?
Yeah, no, I totally agree, Brock, with what you're saying and what Alejandro was saying. The only one thing that I would add is that also the fact that we've seen so many out-of-court processes so far, I think it has to do with a couple of things. One is that in the case of Mexico, as in other countries, the banking sector has provided some relief to companies through covenant waivers and pushing out or capitalizing interest, pushing out some amorts, so on and so forth through year end, right? Or in some instances even less than year end. So obviously all of that has been negotiations that have taken place between the companies and the banks on an out-of-court basis. But I think, you know, as time passes by and we start seeing the dimension and implication that this crisis may have in the company's performance, once these relief provided by the banking sector is gone, then we may start seeing some additional in-court processes. Right now, the number of in-court processes, as you all know, is very limited. But as the effects of the crisis continues and becomes deeper into the company's operation, we may see the need for that tool that Brock is making reference to, that companies may need to actually use an in-court process because it may be the best option to protect the companies going forward. So we'll have to see how things played out, and we'll have to see whether companies elect to use Mexican courts or, as Stephen was making reference to, U.S. courts, looking for these, you know, restructuring hub concept.
Okay, excellent. Look, I should say we are receiving a number of questions from the audience, so thank you very much. We will get to those shortly, but I kind of just want to touch again on this issue that I guess several of you have raised, and that is that we are seeing more Latin American and Mexican entities looking to file for Chapter 11 in the US. I know we've kind of covered it, but I'm interested to know what's driving that trend. I mean, does anyone have any views on that?
Well, I think the main ones that have done it are Aeromexico, Avianca, and LATAM Airlines in the initial go around. And I think you'll probably see some more of the offshore drillers do the same. But what's really driving it is the capital structure and lease obligations. In Latin America, you know, if you go to Brazil, executory contracts are outside a bankruptcy process. So one of the reasons why the airlines, I think, went to the US courts is basically all of their counterparties have some sort of nexus to the US and the ability to reject the aircraft leases or financing structures. So it's a forum where the counterparties would be, you know, would have to abide by the decision of the courts. Whereas the local insolvency laws, for the most part, don't deal with that complexity. And so combining it with having to get debtor in possession financing of a large amount, the local courts unlikely to be able to deal with that in an effective way. Debtor in possession financing is always a problem to structure in Latin America, given civil law and the general corporate law, and basically who are your counterparties? Yeah. In the end, the problem with going to Chapter 11 is not everyone cares about U.S. law. So if you're a local supplier in Mexico, in Rio, in Bogota, and you don't have a connection to the U.S., you really don't care what the U.S. courts say. And so that's a big twist where you have to look at who are your creditors and who are you going to be able to take care of during a process, as opposed to, you know, a normal US filing where all creditors are stopped and can't be paid. You're going to have to make allowances because there's certain local creditors aren't going to play ball.
Okay. James, I might add a quick thought to what Brock is saying. In the early 2000s, when Avianca first filed for a Chapter 11, 2003, that was considered somewhat controversial. Why is a Colombian carrier filing for Chapter 11 in the US? But of course, as Judge Gropper noted in his opinion in the Chapter 11 case, Avianca had all of those lessors that were US based, and a lot of its contracts had a US nexus. So that worked out well. And another factor that would influence the debtors and even the creditors as to where they file would be the capability of the judicial system and the experience and sophistication of the courts. Of course, the U.S. courts, particularly the Southern District of New York and the Delaware Bankruptcy Court, they've handled a lot of the huge Chapter 11s and particularly large airline bankruptcies. So they have the experience in dealing with these cases. And as Brock was noting, some of the local insolvency laws would not be as accommodating of these types of large airline bankruptcies.
Okay, excellent. Thank you. And Alejandra, I guess I should also ask you, I mean, look, when you're advising potentially a Mexican client on whether to take it to a US court versus a Mexican court, what are the considerations you're weighing up? And I guess, do you see there being any risks there with respect to recognition of a US judgment in Mexican courts?
Yes, you know, as Brock was saying, one of the main issues to consider is what type of point of context have. I mean, your creditors have in US, for example. If you are considering a Chapter 11, first of all, I mean, as a debtor, you need to meet certain standards to be admitted. But let's assume that you pass that test. So the issue is whether what type of creditors do you have, since you have a contract that in many occasions, like an airline, for example, subject to the laws of New York, or loans or credit or bonds subject to the laws of New York, that is not an issue. With respect to even Mexican companies with a Mexican jurisdiction contracts, that is also not an issue as long as they have also points of contacts in US, that many of them. There are some cases, as Brock was saying, that you are facing what I call like pure Mexican vendors, no? That they don't care less, they don't even have a passport, so they don't care about what the US court is gonna say about something, no? So then you need to realize what is the amount, the size of those type of suppliers, and to try to take them in a parallel negotiation. It is not that you're gonna have like a two proceedings, so you're gonna give a different treatment to the one that is subject to the supervised Chapter 11 and to the one that is an open negotiations. But it is a matter of conveying the right message to your counterparties and to explain them that this is a process that is required for the company to emerge. Of course, if you're facing a pure Mexican creditor that just for the sake of fun, they want to drag you into a concurso proceeding, they file for an involuntary, I mean, they will struggle on trying to be success on that, but at the end, they will be shooting to their own foot since, also the Mexican courts will provide you an automatic stay. They will prevent that creditor to foreclose, but the situation is that now you're gonna be immersed into a proceeding that is gonna take you longer to emerge, no? And then the deep financing, deep financing, it's always very important. If you're a Mexican company that basically you do not need a deep financing, I mean, you only need a pause in order to negotiate with your creditors. A concurso works perfectly. How preferably, I would say, pre-pack always. I mean, it's very important to try, whether you're a creditor or debtor, to try to sit down with your counterparty, reach something, enter into standstill, and then in case that it is needed for labor purposes, tax purposes, or for dealing with minorities, a concurso proceeding, always a pre-pack. At least you have more certainty. And we have experienced very successful pre-pack situations, no? But in the case of a Chapter 11, yes, I mean, we have participated in I would say most of the Mexican companies that they have filed for Chapter 11. In many of those situations, it has not been even need to get a recognition in Mexico. I mean, it has been everything successfully restructured, and you continue as a going concern. The problem, I would say, it is when you are not able to continue as a going concern. So you start struggling with getting a deep financing, even with paying in the ordinary course of business to your suppliers or vendors, because that will drag you for sure into mass litigation locally, and that could even take you to involuntary concurso or even to a full quiebra or liquidation. No, again, there's no formula or solution for all the companies. It's a suit that needs to be analyzed depending on the different circumstances of that company. No, but honestly, I would not be concerned about recognition. I would be more concerned about having a very good message channel of communication with all your creditors in order for them to realize that the solution for you is to going through this process to emerge as a going concern. In the case of the airlines worldwide, I mean, this is not a particular situation of an airline. I mean, the airlines, even the solid ones, they saw all of their sales drop to 95, 98%. I mean, this is not a situation of a retail. I mean, the money, the funds that you need to sustain an airline to pay for the leases, all the maintenance, employees, it is huge, no? So from one month to the other month, you could see really a company going into a full liquidation, unless you make that stop, no? And that's what we have seen in LATAM, in Avianca, in Aeromexico, and many other airlines to come.
Okay, great. Am I right in saying there are discussions about amending the law in Mexico going on at the kind of Senate level?
Yes, yes, that's a good question. You know, our concursos law, and I'm going to explain this very quickly. It has been out for 20 years. In fact, it is their 20th anniversary. It has been, again, successful in balanced restructuring when there's really willingness from the parties to restructure pre-packs, or even that are not pre-packs, but at the end, the parties, they have the same spirit and the same objectives. No, whenever you want just to take a concurso as a litigation arena, even if you're a debtor and basically you are using not to pay, or you're a creditor and you're using just to put pressure, that's a sign for a big mess and for not reaching a solution. No, so we actually we have a law that in theory it works, but in the practice it doesn't work in many occasions, particularly when there's a lot of litigation. I mean, in all the jurisdiction, of course, the parties, they need to have the rights and the remedies to defend themselves, to present motions, but you need to have certainty on what is doable and what is not. We do not have specialized bankruptcy courts, so that makes our life a little bit more difficult, because our courts are federal district courts that are basically amparo courts, constitutional challenge courts. They don't like to hear on concursos, and they are not sophisticated on cross-border matters. No, so we are working in two avenues for amendments. No, one, it is, I would say, a major surgery of the concurso law in order to, from all the learning experience from debtors, creditors, and other jurisdictions, to make some amendments to make it easier. But in the meantime, as a consequence of this unforeseen pandemic, at the level of the Mexican Bar Association, we present, and we have been working on an initiative that the idea is just to include a type of fast-track proceeding in order that it's going to be easier for debtors to file to get accepted, because the problem in Mexico is the admission. I mean, in US, we know you will, as long as you follow, of course, the routine, you will make the filing overnight, and the next day you will have the first day hearing and will be accepted. Now, in Mexico, could take months or a lot of dismissals without no reason. So that makes it very difficult to have access to the insolvency law. So basically, it is to have better access, to have a faster process, to give more rules to deep lenders in order to create that appetite. Deep financing in Mexico, we have experienced, like, I would say, like 3 to 5 times. And in all of those cases, it has been when you already have a targeted deep lender that you already identified, and right from the beginning, he's willing to inject into that company and taking the associated risk. But if you really want to go and find your best opportunities for deep lender and have them compete as you do it in a normal case in US, I can assure you that it's almost impossible to do that in Mexico. So that is basically what we're doing. It's now at the level of the Senate. It was some opposition at the level of the banks, because the banks thought, in my view, it's a wrong, with all due respect, view, in the sense that they think that if we have a better insolvency law, that would increase the concursos proceeding. Maybe that's true or not. The thing is that if you have companies that they don't have more options but facing an insolvency in court proceeding, you better cooperate on having a better law that works for both debtors and creditors. No, but we'll see, and we're putting a lot of pressure. I normally, as a restructuring lawyer, that I work in many occasions at the side of the debtors, in many occasions at the side of creditors, international creditors. What I want is a better legal framework in order to protect better my parties. No, but I also would like to hear on this, what Stephen, Brock, or Daniel has to say, because also they have experienced these type of situations.
I would add one quick thought here, and that is that one of the positive developments in the emerging markets in the last 10 to 20 years has been that many of the countries, such as Mexico and Brazil and China and India, they've reformed their insolvency laws to make them more reorganization friendly. The laws had been heavily oriented towards liquidation, and now there's been greater emphasis on making sure the reorganization mechanisms are robust enough. The problem, as Alejandro was explaining, is that the key is the implementation. And in a number of these countries, implementation of the law can be very challenging, to say the least. So yes, there's a more positive legal framework in many countries around the world, not just emerging markets, but advanced economies like Germany as well. But the issue remains implementation, the capacity of the courts, and the independence of courts. So that's the challenge that especially foreign creditors, for example, face when they go into these systems. They might read the local insolvency law and think they understand how it's supposed to operate, but as Alejandro was just pointing out, things that are supposed to happen quickly or happen quickly in your home jurisdiction can take a very long time to happen in some of these jurisdictions.
And if I may add to that, I completely agree on what Stephen and Alejandro were saying, and I do want to highlight because it's really critical. I mean, this point about implementation. Our concurso law is a law that has existed for a few years, and as Stephen was saying, it's a law that has been amended a few times now, and it's in the process of being amended. And the truth of the matter is that the law has gone a long way. I mean, we have incorporated a lot of the good concepts that we've seen work in other jurisdictions. And we have a DIP concept, we have contract rejection concepts, we have, timing concepts, so on and so forth. And there are still some differences, and definitely it can be improved and should be improved, as Alejandro was saying. But the key difference, in fact, is the implementation. I mean, when you look even at statistics of how long process takes, I mean, when we talk about a pre-pack in the US, I mean, we've done pre-packs in 20 days, right, or less. When you look at a pre-pack in Mexico, I mean, probably in recent times, the faster that we've seen it is 6 months, probably a little bit less, but not 20 days. And not at the level of efficiency that we've seen in other jurisdictions. And that has to do with a lot of things, and we can all, speculate about that. Clearly, the legal system, the lack of specialized court, as Alejandro was saying, is something very, very important. I mean, we really need judges that are very familiar with this type of process, that are very familiar with corporate finance concepts, that understand financial markets, that understand the way creditors think, and that can take decisions in a very expedited fashion. So we have a way to go with respect to implementation. We should continue improving also with respect to some law matters, just to name a few of them. Again, the timing of the process, for example, is an area where we have improved. On one hand, in the past we had pretty bad experiences in Mexico where we had cases that have taken many years, and there is a case that took more than 20 years, right? Being in an in-court process, so something really unseen in other jurisdictions. So we changed the law, and we have now we have a time limitation in the Mexican law, whereby, for example, in Chapter 11, what you have is an exclusivity limitation for the debtor to present a plan of restructuring. So there are some differences in Mexico. If you want, for example, if you want to capitalize or equitize claims, you need a shareholder approval. In the US, you don't need that. So that creates some dynamics and some inefficiencies in some instances that makes it a little bit harder. So we have, some areas of improvement in the Mexican law for sure, but one of the key areas is really the implementation of the law.
Okay. And can I just ask as a follow-up, Daniel, just to put it in very kind of clear terms, I mean, as a financial advisor, I guess, Brock, you can also comment here. I mean, do you advise creditors to at least try to negotiate a pre-pack, or should they just file a voluntary petition without a pre-pack?
No, absolutely. I mean, if we are thinking of using concurso mercantil, if we have the time and the ability to negotiate a pre-pack, if we want to use concurso, the way to go, as Alejandro was saying, is definitely to try to use a pre-pack, because otherwise, it takes, a long time, and it adds uncertainty into the process. So pre-pack is the way to go, particularly now that we have in Mexico limitation of up to 24 months, up to a year time to restructure, right? So we need to be very efficient, very diligent, meaning when you enter concurso mercantil, you need to have a very clear path, a very clear plan to get things on in a now relatively short period of time. And if you have a case where it's only one entity, one company filing, and it's just a matter of negotiating a simple plan, that's really not a concern. But if you have a company where you have a holding company and 20 subsidiaries, and you're filing all of them, and you have multiple creditors, and you have bonds, local and foreign, and you have derivatives, and you have bank debt, and so on and so forth, that's really when you get very concerned. And you want to make sure that when you enter into a process, an in-court process, at least in Mexico, you know clearly the path that you're going to take, and you have the votes in one hand when you're filing. And definitely the way to go because of that is to do it in a pre-pack fashion.
Okay, great.
And even if you have the votes, the problem that Alejandro talked about is the amparos, and basically a creditor basically holding up the restructuring implementation. And you get into situations where one creditor can derail the process. And I think the one thing we're going to see, like normally we have deals where Daniel and I talk, Daniel has one side of the table, I'm on the other side of the table, and we talk to each other for 18 months, and then we come to the finish line. I don't think we have the luxury this time in this environment to do that. Like, I think this is going to be the 4 to 6 month process, or the company's going to be out of business. And so the implementation becomes a really significant aspect of what we're going to see going forward. I don't think we're going to see the 12-month restructurings that we have in the past. And the problem you have is with implementation, like, it's a 12-month process, but there's a hotel company that's in year 9 or year 10 of the concurso mercantil. And, site, because good litigators, I guess, depending on how you look at it from whose perspective, are able to continue the process indefinitely. And so I think going forward, we're going to see in the short term, 4 to 6 months, got to negotiate out of court and try to avoid to go to court if at all possible.
Okay, excellent, great. Look, I just want to come back to Alejandro, if I may, to ask you, this situation that we've been discussing, is there a risk here of companies taking, sorry, a bit of background noise. Is there a risk of companies taking a kind of short-term approach to restructuring here? I mean, are you entering into restructuring that is going to end up requiring huge interest payments, and that's just going to compound the problems they face?
Yeah, yes, for sure. And that's something that we have been seeing a lot, in the sense that the companies, due to this uncertainty that they don't know at all what's going to happen with the market, they take a rapid anchor on what the banks are offering on just dealing with extending the payment of interest, or in some of the cases just kicking the can on the maturity of the principal amounts, or continue paying interest. And I think that here is very important to know what our speakers here were saying, in the sense that now it's a continued revision of the business plan and on the different factors that will be affecting your market. So I see that it's going to be very, very few cases that the solution is a short term on only dealing with a not paying principal or not paying interest during the next 4 months or 6 months, because those will be big payments. So at the end, you have a larger amount of debt, and you don't have a better cash flow, and you don't have better sales. So that is the reason that I think that always you need to anticipate yourself. And even from the creditor's perspective, even from the bank's perspective, maybe you want to avoid an event of default. Of course, from the debtor, you want to avoid ending in situations of capitalization index or requirements on reserves. But at the end, you need a company that is going to be able to pay you the principal amounts at the end, not only dealing with the payment of interest. No, so we have seen, yes, an appetite from the banks to trying to resolve this short term, just to see what's going on and to take time, and companies doing that. No, but again, if you do not anticipate yourself, you're going to be in worse situation in 3 months than what you are now.
Okay, great. Look, I want to leave time for questions, but just finally, I guess we can get a bit more of the kind of bigger picture context from you, Stephen. So I'm interested to know, obviously, you're an expert in sovereign debt. I mean, how has the sovereign debt situation been impacted by the crisis, particularly, I guess, in countries like Argentina and Venezuela, where they're up to their eyeballs in it?
Sure. Thank you, James. Well, many of these countries had problems even before the COVID crisis arrived. Argentina was in trouble before COVID, but the pandemic has made their problems worse because, as I was indicating earlier, the governments have to spend money on public health responses, and also they're trying to put together economic recovery and stimulus programs. So the sovereign debt situation only promises to get more challenging in the coming months and the next year or two, because there are so many countries around the world that will have these public finance problems. Now, just in the last week, of course, Argentina reached a deal with its creditors on the foreign bonds, $65 billion of bonds. And those discussions had been going on for a while, for several months, but they came to a deal just early last week. Ecuador has also come to a deal with its creditors recently. But then there are some very problematic cases still outstanding. You mentioned Venezuela. Venezuela is just a very terrible situation, particularly from a humanitarian standpoint. But Venezuela also has a huge outstanding debt burden. It's estimated to be 150 billion or more. And but the problem with Venezuela is that no one anticipates a restructuring taking place while the current government, the Maduro regime, remains in power. So there won't be any progress in the near term, but even if and when there's a change in government, doing a restructuring for the Venezuelan sovereign debt is going to be incredibly complex, because for one thing, you're not just dealing with the sovereign, the Republic of Venezuela, you're also dealing with their other major debtor, the state-owned oil company, PDVSA. So, and then the economy is in virtual collapse. The oil industry is in tatters. And so the Venezuelan situation will be very, very difficult. Lebanon was having problems before COVID. Now, this explosion last week that promises only to make the situation even more difficult. And there are some countries that have been hard hit by the commodities decline. For example, Zambia is a major copper producer. It's been hard hit by the drop in copper prices. And that will be a complex restructuring, because you have foreign creditors, foreign bondholders, and then you have China has loaned several $billions to Zambia. And then the IMF has been approached by Zambia to provide financing. So that will be a very challenging situation, because China will be a major player, and China typically has tried to do these sovereign restructurings on its own. Now it will have to see how it works with other creditors.
Okay, great. I was going to ask you about China, but I guess you've covered it. Okay, excellent. Look, we do have some questions from the audience if the panel still has time to address them and give us any further thoughts they may have. So one question is about the energy and infrastructure sector in Mexico. So it's not just COVID-19 that's creating headwinds in particularly the energy sector. You've got falling demand, suboptimal political conditions. So do you anticipate a lot of restructuring and I guess distressed M&A opportunities for the energy and infrastructure sectors? I don't know who wants to take that. Maybe Brock as a starter. Any thoughts on energy and infrastructure?
I think the problem with the infrastructure is the government's ability to fund the infrastructure. And you're seeing in Mexico and Latin America that, with trying to, for the most part, the governments aren't really supporting companies or individuals to the same extent that you're seeing in the US. And so, your normal playbook to invest in infrastructure as a way to create jobs, etc., for all intents and purposes, that's been shut down for 3 or 4 years now in Latin America. And I just can't see it starting up as a result of COVID. So all of the countries have significant deficits in infrastructure. I just don't see the funding being available to go down that road in the near term, absent some international monetary fund financing to these governments.
And just adding to that, I mean, clearly both sectors, the infrastructure sector and the energy sector, are capital intensive. So whenever there are obviously impacts in the market, I mean, companies that have significantly amount of debt in their balance sheet obviously could suffer, and as a result of what's going on, we could see some of that happening. I think that in addition to that, one thing to consider is some changes of rules or regulations taking place in the country. And as a result of that, whenever you change the rules of the game to certain companies, we could see some disruption in some business models. And as a result of that, that could lead us to some renegotiations or restructuring of debt for sure. But I think it's, in my view, I think it's a little bit early to tell exactly which way this would go. Again, it's going to depend on what is the length of this crisis and what is the impact of some of these initiatives in some of these sectors, particularly the energy sector.
James, if I might, from a global perspective, I had mentioned China just a minute ago, but we're likely to see a lot of distressed projects associated with China's Belt and Road Initiative. And they have projects all over the world. And so it will be very interesting to see how China handles those renegotiations as they arise. But they've been a major funder of infrastructure through those projects. So that will be something to keep our eyes on as we move forward.
Particularly, I guess, in Latin America. I mean, the US has always historically seen Latin America as its kind of backyard, and there's been a striking rise in China's investment into the region. I mean, how much of that is actually real investment and how much is going to the BVI and routing back to China is a moot point, but is that changing the landscape?
Well, in Venezuela, China is the largest bilateral creditor to Venezuela. It has about 20 billion in outstanding debt to Venezuela. And so they've been involved with some of the oil projects and so forth. Of course, Russia is also involved, but their outstanding exposure is more limited at this point. But if and when we finally get to a Venezuelan restructuring, China will be a major player, given the size of their exposure.
Okay, excellent. Look, got a couple of questions, which I guess, Alejandro, you're best placed to address here. So a question from Jorge Zapata. So Jorge asks, what happens if shareholders, or at least a subset of them, have to pay some back? Sorry. So Jorge's question is, what happens if shareholders, or at least a subset of them, do not agree with an insolvency procedure, a concurso? What are the consequences that unfold then?
I mean, sorry, I didn't follow the question. In the sense that
if they don't agree with the insolvency procedure. So if the shareholders say no, we don't.
Oh, okay, good. I mean, the main issue in Mexico it is that in principle you do not need any shareholder consent with respect to the treatment of the debtors. In principle, because of course, in order to go into a concurso proceeding, you need to pass a corporate resolution that could be at the level of the shareholders or at the level of the board, if your bylaws allows the board of directors to be empowered to make the filing. Okay, once you are in the concurso proceeding, in principle you are not affecting the interests of the shareholders, but you are just dealing with the claims of the debtors. Okay. However, the things become a little bit complicated when you need to implement as a part of the organization plan a debt into equity conversion, and that requires a dilution of the existing shareholders. It is not enough to have a court approval approving the plan, but as a matter of civil and corporate law, you need to pass a shareholder resolution approving the capital increase. No? So of course, if you do not have the support of your shareholders to have the quorum to pass a capital increase, then there's no way to pass an organization plan, even if the creditors are willing to do that. No? But if you have the majorities required, and as long as you comply with the law, with the bylaws, with whatever is doable, you should not have any issue. Of course, always there's a situation that a minority shareholder may try to challenge that, but the law works in the sense that that would be possible to avoid. No? So yes, sometimes you have a minority shareholders being difficult for a process, but in most of the cases, I think that the shareholders are aware of what is required in order to preserve the company.
Okay, excellent. And Alejandro, another question for you. Given what you said earlier, someone asks, why aren't we seeing mass layoffs among larger Mexican companies? Is there a reason for that? And are we going to see them? Well,
I think that's a good thing that we haven't witnessed to that extent. I think the situation it is that the business, are aware about this social program. So that is the reason that they have an approach to the creditors, to the banks, to the suppliers, in order to preserve the going concern and the rights of the employees. The labor rights in Mexico, we don't have employment at will. So if you want to terminate a labor relationship, you need to pay for the severance. And those are rights protected by our Mexican constitution and by our federal labor law. No, even in the case of an insolvency, the rights of the employees, they rank senior. No, but I think that at this stage, it's more, I would say, a combination of a social awareness of the board of directors, the companies, the shareholders. They try to preserve the employments of the people in this very difficult time for everyone. And on the other side, also, we have seen a lot of solidarity from employees that even they're willing to temporarily to reduce their salaries, their perceptions, to be open, to take back pre-vacations and things like that. No, hopefully we're not going to see major layoffs, but the consequence is that if there's no the willingness between creditors and debtors to find solutions, for sure we're going to see quiebras, liquidations, and if that is to happen, of course we're going to see layoffs. No, but we'll see, and hopefully also it comes a bigger support from the federal government, particularly to continue having the flows required to preserve the going concern and the payment to employees.
Okay, excellent. Look, guys, I think we will have to wrap up there. I know Daniel has a hard stop, but thank you very much. Thank you to Stephen, to Brock, to Daniel, and of course to Alejandra. And also huge thanks to Cervantes Sins for putting this together. Any final thoughts from anyone before we finish? No, in which case we can leave it there. I will just say a video of this webinar will be posted on the Legal 500's website shortly. So if you have any follow-up questions or further points of clarification needed, you can contact us through that link. We'll make sure it gets to the appropriate people. So thank you very much. Goodbye.
Thank you so much, James. Brock, Daniel, Stephen, it has been a pleasure sharing the panel here.